So, hello. Let's continue the discussion. Kakatapos lang natin sa Title 4. Now, let's go to Title 5, which talks about the bylaws of the corporation. Now, before we start with this discussion, ano nga ba itong bylaws of the corporation? Like, anong difference niya sa articles of incorporation? Ano basically yung nature niya? Now, in connection with that, I will give you this analogy. Basically what differentiates the articles of incorporation from its bylaws. Now, ganito. Ang articles of incorporation, parang ganito siya. Pupunta ka sa grocery para bumili ng supplies mo sa bahay. Sabihin natin yun yung articles of incorporation mo. Now, ano yung bylaws? Yung bylaws is like this. In connection with that, sasabihan mo ang tatay mo na ipagdadrive ka papunta sa grocery kasama ng iyong nanay kung saan kukuha kayo ng cart at saka iikutin nyo yung grocery at pipiliin nyo kung ano yung mga kailangan yung supply sa bahay, iisa-isayin nyo, pupunta kayo sa meat section, sa cheese curls, sa mga noodles, hanggang sa makumpleto nyo yung mga supplies na kailangan nyo sa bahay na kung saan may list kayo kung ano mga kailangan nyo. After completing that list, checking all the necessary supplies na kailangan nyo, pupunta na kayo sa counter para magbayad sa cashier. And after that, uwi na kayo sa bahay, susunduin kayo ng tatay nyo. At pagdating nyo sa bahay, wala, meron na kayong supplies nyo sa bahay. Yun yung bylaws. Yun yung analogy for the articles of incorporation and sa bylaws. So, let's start with section 45. Adoption of bylaws. So, for the adoption of the bylaws by the corporation, the affirmative vote of the stockholders representing at least a majority of the outstanding capital stock or of at least majority of the members kapag non-stock shall be necessary. So, kung mag-a-adopt ng bylaws yung corporation, kailangan may affirmative vote galing sa stockholders. But in this case, pansin nyo, hindi 2/3, but rather majority lang. Now, the bylaws shall be signed by the stockholders or members voting for them and shall be kept sa principal office ng corporation subject to the inspection of the stockholders or members during office hour. Yung a copy thereof, duly certified by the majority of the directors or trustees and countersigned by the secretary of the corporation shall be filed with the commission and attached to the original articles of incorporation. So, ganyan yung nangyayari sa pag-adapt ng bylaws. Now, sir, pwede bang isabay yung filing ng bylaws sa articles of incorporation? Yes, mas prepared pa nga ganun eh. Notwithstanding the provisions of the preceding paragraph, bylaws may be adopted and filed prior to the incorporation. In such case, such bylaws shall be approved and signed by all the incorporators and submitted to the commission together with the articles of incorporation. So, whether pwedeng mauna ka magbigay ng bylaws sa Pwede kang mauna magbigay ng bylaws kasabay ng articles of incorporation mo. Isabay mo. Mas preferred pa yung ganung pag-submit. Para aswan na yung pag-approve ng Securities and Exchange Commission para mag-release siya ng Certificate of Incorporation. Kasi yun yung usual yan eh. Yun yung preferred way. Now, in all cases, the bylaws shall be effective only upon the issuance of the commission of a certification that the bylaws are in accordance with the corporation code. So, magiging effective lang yan. Magiging effective lang yan. Yung date effectivity niya, may visa lang yan kapag yung SEC natin nag-issue ng certification na sinasabi the bylaws are in accordance with the code. Now, the commission shall not accept for filing the bylaws or any amendment thereto of any bank, banking institution, building and loan association, trust company, insurance company, public utility, educational institution, or other special corporations governed by special laws unless accompanied by a certificate of the appropriate government agency to the effect that such bylaws or amendments thereto are in accordance with law. So ito yung mga special recommendations na discuss natin last time. Kaya ng mga banks, mga under sa general banking law, yung mga insurance company, mga public utilities, kailangan pag magano sila ng bylaws, mag-submit sila o mag-file sila sa commission, kailangan may certification galing sa appropriate government agency in relation to their industry. So yan, adoption of bylaws, majority lang. Then, pag mag-incorporate ka ng corporation, isabay mo na sa filing mo ng certificate of, sa filing mo ng articles of incorporation with the Securities Exchange Commission. Now, salient points. Now, the revised corporation code removed the required 1 month. Wow, crap. The revised corporation code removed the required 1 month to adopt the bylaws. Kasi dati, sa old corporation code natin, sa BP 68, kahit na na-release na yung articles of incorporation, yung certificate of incorporation, in-issue na ni Securities and Exchange Commission, you still have 1 month within that, 1 month after that issuance of certificate of incorporation para mag-submit ng bylaws mo. Oo, dati pwede yun. Like, mag-submit ka ng articles of incorporation, yun lang. Then yung CSEC mag-issue ng certificate of incorporation kahit wala ka pang bylaws, may 1 month ka to submit. Ngayon, tinanggal na yung provision na yun. Oo, basically, dapat isabay mo na sa filing mo. Oh? Must be filed together with the articles of incorporation. So yun, di ba nagbigay tayo ng analogy kanina regarding sa ano yung bylaws, anong connection niya sa articles of incorporation. Dito tayo ngayon sa meaning of the bylaws. So bylaws may be defined as the rules of action adopted by the corporation or association for its internal government and for the government of its stockholders or members, and those having the direction, management, and control of its affairs in their relation to the corporation and among themselves, including rules for routine matters such as calling meetings and the like. So yan. Yan yung bylaws. Basically, i-clear natin. Yan yung rules and procedures when it comes to the internal governance of the corporation. Yan yung bylaws. Okay? Rules and procedures when it comes to the internal governance of the corporation. Paano patatakbuhin yung corporation? Yan yung meaning ng bylaws. Now, the power to adopt bylaws. This is also a power of the corporation. Now, the power to adopt the bylaws, the corporation is expressly granted under Section 35-5 and Section 45, this section. Although, this power is inherent naman within every corporation because it is one of their necessary and inseparable legal incidents. Kasi, as we have said, bylaws ang needed para sa rules and procedures on the internal governance of the corporation. Kapag wala yung power na yan, lagot ang corporation. Paano yan gagana yung makina ng corporation? The machinery on how the corporation operates. So, kailangan yung bylaws para dyan kasi that bylaws is the machinery on how the corporation operates. Now, this power is regarded as of so much importance, being essential to enable the corporation to accomplish the purpose of its creation that is ordinarily conferred in express terms by the law. Kahit na yung mga non-voting shares, mga non-voting members, pwede silang or entitled silang bumoto sa adoption ng bylaws. Kasi kung titingnan nyo dito, saan ito? Ay, mali pala yung naisip ko. So, yan, kahit mga non-voting members. Now, what is the function of the bylaws? Ito rin yung napansin ko sa difference ng bylaws sa previous corporation code and sa new corporation code. Kasi yung bylaws sa previous corporation code, by-laws. Pero yung bylaws sa sa revised corporation code, wala nang dash, laws agad. Yan yung style ng writing na ginamit nila. So, bylaws supplement the articles of incorporation. Because the bylaws provides the details not important enough to be stated in the articles of incorporation. Kasi kung lagay mo sa articles of incorporation yan, haba ang articles of incorporation mo. Kasi naglagay ka ng specifics eh. So, ang sa articles of incorporation mo lang, yung general idea. Yung specifics, nasa bylaws na. Okay? Articles of incorporation, the general idea, the overview, the broad one. Pagdating sa bylaws, specific, narrow, yan na. So, until repealed or amended, a bylaw is a continuing rule for the government of the corporation and the individuals composing it. So, the function of bylaws define the rights and duties ng corporate officers, directors, trustees, the stockholders, and members towards the corporation and among themselves with reference to the management of corporate affairs, regulate transactional business corporation in a particular way. Yung bylaws is the source of authority for corporate officers and agents of the corporation kasi nasa bylaws kung paano o nasa bylaws yung guidelines, yung rules and procedures on how they will operate, kung paano nila gagawin yung kanilang trabaho, ano yung mga duties nila. Ganun. Now, bakit mahalagang mag-adapt ng bylaws yung corporation? Parang na-mention naman natin ito kanina, pero implied din, pero ito, mas expressly stated the necessity of adapting the bylaws. So, it is a matter of practical and legal necessity. Why? Because upon the issuance of the certificate of incorporation, the corporation comes into existence. Excuse me po. However, it is not yet prepared to do business. Kasi anong gagawin mo sa articles of incorporation mo? Kasi napaka-broad yan eh. So, kailangan you must have the means or instrumentalities for the accomplishments of the purpose of the corporation as stated sa kanyang articles of incorporation. Trabaho yan ni bylaws. So, the corporation is in existence but not yet organized. A code of bylaws for the government of corporation, its officers and members must be adopted. It has been said that the bylaws of a corporation are the rules of its life and adapted. So, paano ginagawa si bylaws? The construction, application, and effectivity niya. So, bylaws of a corporation should be construed and given effect according to the general rules governing the construction of contracts, providing this imprisonment, etc. Bylaws. Okay, basahin niyo lang yan. So, the validity of the bylaws. The following are considered as the elements of valid bylaws. They must not be contrary sa existing laws including the code, must not be contrary to morals and public policy, so lamok, POPs, etc. Must not impair obligations of contract. Big sabihin, kapag may kontrata ka, tapos yung kontrata na yun na valid, hindi mo pwedeng i-chapwera yon. Kailangan mong gawin yung obligasyon mo sa contract na yon. Kasi kapag in-chapwera mo yon, without any justifiable reason, that is impairing the obligations of contract. And the only thing that can impair the obligations of contract is the police power of the state. Yun lang ang pwedeng mag-impair sa obligations ng contract. Kasi kahit yung mga taxation, eminent domain, you cannot impair the obligations of contract. Police power lang. So ito, pinag-usapan natin dito, bylaws lang. So the bylaws has no power to impair the obligations of contract. They must be general, uniform, and operation, not directed against particular individual, meaning dapat hindi sa discriminatory. Must be consistent with the charter of corporation, and they must be reasonable. Now, what is the binding effect of the bylaws? Lalo na sa mga tao, sa mga individuals in relation to the corporation. Now, ito, first, as to the corporation and its officers, the bylaws as the self-imposed private laws ng corporation, kasi internal governance have when valid substantially the same force and effects as laws of the corporation, as have the provisions of its charters insofar as the corporation and the persons within it are concerned. Kasi it's between them. It's the internal governance. Paulit-ulit natin sinasabi. They are in effect written into the charter and in this sense, they become part of the fundamental law of the corporation. Now, when it comes to the corporation and its directors or trustees and officers, they are bound and must comply unless and until they are changed, amended, or repealed in accordance with Section 47. Kasi Section 47 talks about the amendment of the bylaws. But subordinate employees without actual knowledge of the bylaws are not bound. Now, when it comes to the corporation and the stockholders and members, it is general rule, you cannot presume or the stockholders and members of the corporation are presumed to know the provisions ng bylaws ng corporation. Obviously kasi stockholder ka, mag-i-invest ka sa corporation, di mo alam paano yung pinapatakbo. Dapat may idea ka. Same with the members. Now, paano naman as to third persons, yung taong walang connection, hindi nagtatrabaho for the corporation? Anong labot niya pagdating sa bylaws? Well, the weight of authority is that they are not bound by the bylaws of the corporation. Siyempre, anong pake ng third persons? Hindi naman siya nagtatrabaho sa corporation. Hindi siya under jurisdiction ng corporation. So, walang labot yung bylaws sa kanya. Since the bylaws operate merely as internal rules among the stockholders. Now, there's an exception. When the third person has knowledge of its provision, either actually or constructively, at the time of the transactions in question was entered into. So, parang naging bad faith siya. I know this is bad faith, pero naging may assumption, alam niya na kasi eh. So, may idea na siya. So, hindi na siya pwede mag-presume ng innocent or ignorance. Kasi, may idea na siya. Ano yung bylaws, yung subject bylaws in relation to that instances. Now, let's go to section 46, which talks about the contents of the bylaws. Anong laman yan? Mahalaga to kasi dati, pero di ba yung pinapagawa ko sa inyo na sa paggagawa kayo ng corporation. So, since, obvious naman so sabihin ko na lang na dapat kasama ng Articles of Incorporation yung bylaws, so gagawa rin kayo ng bylaws. So ito, anong contents ng bylaws? Pero don't worry naman, pakahanap rin naman kayo sa internet, dami niyan. Kami nga sinulat lang namin. So, the contents of the bylaws, a private corporation may provide the following. May provide the following in its bylaws. Time, place, and manner of calling and conducting regular special meetings para sa board. Time and manner for calling and conducting regular and special meetings para sa and mode of notifying sa stockholders or members thereof. Lalo if allowed by the bylaws of the corporation, pwedeng electronically na lang. Ito, the required quorum in meetings of stockholders and members and the manner of voting. Usually ang quorum natin is, unless otherwise stated, majority. Pero the bylaws can provide an mas increased portion. Like, for example, instead na majority na lang, 2/3 ang quorum. Pwede ganon. The modes by which a stockholder, member, director, or trustee may attend meetings and cast their votes. Pwede na sabihin, taas-taas kamay lang, or balot sila. Pwede na i-provide ng bylaws. The form for proxies of stockholders and members and the manner of voting for them. Itong proxies, basically, other word brand, substitute mo. The directors or trustees qualification, duties, responsibilities, guidelines for setting the compensation ng directors or trustees and yung officers, and the maximum number of their board representations that an independent director or trustee may have, which shall, discuss natin yung independent director sa previous videos, shall in no case be more than the number of prescribed by the commission. And there's the time for holding, the annual election of directors, and the mode of manner, kung kailan gagawin yung mga election nila, kailan i-held, saan i-held, the manner of election or appointment ng term office ng officers other than the directors and trustees, penalties for violation of the bylaws, termination of contract na ba, patatanggalin na ba sa corporation, baka suspension lang, depende sa gravity ng offense. In the case of stock corporation, the manner of issuing stock certificates and such other matters as may be necessary for the proper convenient transaction of its corporate affairs, for the promotion of good governance and anti-graft and corruption measures. Ito, additional, an arbitration agreement may be provided by the bylaws pursuant to section 181 of this code. So, salient points and remarks. Anong mga pinagbago nito since the old corporation code, BP 68? So, this revised corporation code provides that the bylaws may include a provision in which the modes by which stockholder, member, director, trustee may attend meetings and cast their votes. This is a congruence to the revised corporation code allowance of voting in absentia. So kahit wala ka sa or hindi ka physically present sa meeting, pwede ka pa rin makaboto gaya ng electronic mail, etc. So, ano mga changes? Provide for the proper or convenient transaction corporation for promotion of good governance, anti-government, etc. Meetings cast, maximum hour presentation, arbitration agreement. Okay, purpose holding meeting, ito yung agenda. So, ito yung content, place of meeting. So, meeting, di ba? As you have said, yung meeting ng directors and trustees ng board, pwede kahit saan sa Pilipinas. Kahit saan sa mundo. Gusto mo ilan na party ka dyan, goods lang. Pero pagdating sa stockholders and members, may napag-usapan natin, na-discuss natin kung yung specific limited lang option nila. Yung quorum naman, di ba, sabi natin, pwede silang prescribe a higher number greater than the majority. Pwede ilagay 2/3 or 3/4 para mag-constitute ng quorum. So, proxies, basically the substitute to eh. Ma-discuss natin to sa Title 6. Qualification of directors. Siyempre, ang binigay lang, ang provided lang naman sa natin is, diba, discuss natin yung qualification ng directors. The minimum legal requirement is at least owner siya ng 1 stock. Di ba? Disqualification. Silence ko muna phone natin. Disqualification for position directors, ano mga offenses or violations para ma-disqualify siya, compensation to stockholders or members, attendance of election of terms, to discuss na imposition of penalties and sanctions, said, issuance of certificate stock, read na lang. So ito, section 47, paano natin ina-amend yung bylaw? Siyempre, kailangan ina-update yan natin para adaptability ba? Kung may mga certain changes na kailangang palitan, sige, amend yung bylaws to go in time. Anong tawag dito? Anong phrase yun? To go in time? To go in line with the time? Kalimutan ko. So anyways, section 47 provides for the amendment of the bylaws. So amendment to bylaws, a majority of the board of directors or trustees and the owners or a majority of the board of directors or trustees and the owners of at least a majority of the outstanding capital stock or majority ng members kapag non-stock at a regular special meeting duly called for the purpose, pwede nilang i-amend or i-repeal yung bylaws or pwede silang mag-adapt ng bagong bylaws. So tingnan nyo, majority lang. General rule, majority lang ang kailangan. Majority ng board, majority ng stockholders. Basically ito, majority ng quorum to. O yan, no? So with that, joke lang. So yun, majority general rule. Pero pwedeng i-delegate. Pwede yang ma-delegate. Paano? I-delegate ng stockholders or ng members sa board yung pag-amend ng bylaws. Paano i-delegate? The owners of the 2/3 of the outstanding capital stock or 2/3 ng members in a non-stock corporation, they may delegate to the board of directors or trustees to amend repeal the bylaws or adopt new bylaws. So basically, nagsasabi dito, sige, kayo nang bahala dyan, board. Sabi ng mga stockholders o members, so sige, boards, kayo nang bahala dyan sa pag-amend, repeal, or mag-adopt ng new bylaws to corporation. We will delegate you this power. Hindi na kami makakialam dyan. Kasi dito sa una, kasama yan sila. Pero dito sa delegation, si boards na, yung board of directors or trustee na yung bahala. Now, but take note, that delegation can be revoked. Pwede yang bawiin. Paano? That any power delegated to the board of directors or trustees to amend or repeal the bylaws or adopt new bylaws shall be considered revoked whenever the stockholders owning or representing a majority of the outstanding capital stock or the member shall vote so at a regular or special meeting. So as you can see here, yung pag-delegate 2/3. Pero yung pag-revoke ng delegation, majority lang. Di ba? Whenever the bylaws are amended or new bylaws are adopted, the corporation shall file with the commission to ministerial to procedural matters such amendment of new bylaws, if applicable, the stockholders or members resolution authorizing delegation of power to amend the duly certified by the secretary. The amendment of new bylaws shall only be effective upon the issuance by the commission ng certification that the same is in accordance with the code and other relevant. So magiging effective lang siya, may bisa lang yung bylaws nyo kapag si commission, si Securities Exchange Commission nag-issue ng certificate. So amendment and repeal of the bylaws. So power implied, the power to make the bylaws, the power to make the bylaws implies the power or includes the power to alter or repeal them and enact new ones, mag-adapt ka ng bago, but the power to alter bylaws or adapt new bylaws has the same limits as the power to make them in the first place. So basically, the power to create gives you the power to alter, the power to appeal, the power to destroy, the power to adapt new one. But kapag gagawa ka ng bagong bylaws or mag-adapt ka, mag-alter ka, yung limits na sinabi natin dito kanina, saan yung limits na yun? Diba nilista natin yung limits? Saan yung limits na yun? Oy, lumampas. Ito, limits. Yung pag-create mo ng bylaws, yung limits doon will also apply to the altering, to the repealing, and to the adopting of new bylaws. Yung ganito, ito yung mga limits. So, formality's sake, ito ministerial na to or procedural matters. Provides the formalities to be followed making the bylaws for a greater number of votes. In all cases, the power can only be exercised at a regular. Section 47 provides that the formalities to be followed in making amendment or repeal of the bylaws or in adopting new bylaws. The bylaws may provide for a greater number of votes. In all cases, the power can only be exercised at a regular special meeting duly called for the purpose. Even yung mga holders ng non-voting shares or mga non-voting members, as we have said kanina, pwedeng mag-vote. Now, the delegation of the power, ito na-mention natin. The power may be exercised by the stockholders or members directly, like yung majority sila ng board of directors, or pwede nilang ma-exercise yung power na yan indirectly by delegating said power to the board of directors or trustees. Like, gaya sabi natin, sige, kayo nang bahala dyan. De-delegate na namin sa inyo. Kailangan ng 2/3 doon, di ba? 2/3. Pero yung pag-revoke nun, majority na lang kailangan. So, lesser number of votes required. To sabi natin, the evident purpose of this is to make of the law is to make it easier to revoke the delegated power. Bakit? To safeguard against possible abuse of power by the board of directors or trustee. Yan yung reason bakit majority na lang kailangan sa pag-revoke. Kasi di ba? Pag mag-delegate ka, 2/3. Pag mag-revoke ka, majority lang. Bakit? Para to safeguard against possible abuse of power. Kasi masyadong malaki ang 2/3 eh. Paano pag yung mga majority lang? O para mas less yung kailangang effort pag mayroon pa to revoke that para ma-safeguard or para ma-prevent ba yung abuse of power. So, ito pa. So, bylaws and resolution distinguish. So, ano ba itong list? Diba? May tatawag tayong board resolution. Yeah? So, anong kaibahan niya sa bylaws ng corporation? Now, in addition to the bylaws, a corporation may adopt other rules and regulations for its government, which may be in the form of board resolutions. As we have said, from the word itself, board resolution, meaning yung board of directors or trustee yung nag-issue niyan. Now, generally speaking, bylaws and resolutions are recognized and treated by the courts as distinct and different. Magkaiba talaga sa dalawa. Not merely in name, but with regard to their respective offices, functions, and operations. Nature and subject matter. Anong difference na dyan dalawa? Now, a resolution merely is a declaration ng will ng corporation in a given matter and in nature a ministerial act. Yan lang si board resolution. Yung bylaw naman, permanent rule of action. Alangan. Kung gumawa kayo ng bylaws, sinabit nyo sa SEC for approval. Ang SEC nag-issue ng certification. So, yung bylaws na yan, ironclad yan. Its permanent rule of action talks about the rules and procedures ng internal governance. Walang, hindi yan kakayanin ng, or tawag dito, wala, yung Board of Resolution, wala yan sa powers ng bylaws. Except only so far may be repealed or amended of the conduct of corporate affairs while resolution is ordinarily limited in its operation, applying usually to a single act or transaction of the corporation or to some specific person, situation, or occasion. Rules in case of conflicts, kapag may conflict between the bylaws and the resolution, mananaig yung bylaws. Necessity of approval, yung bylaws, kailangan approval ng SEC, yung SEC, yung commission natin, mag-issue ng certificate. Yung other rules and regulations, yung natin, board resolution, hindi kailangan ng approval unless they involve matters where the law requires approval. Ito, lastly, articles of incorporation natin, na-discuss natin yung kaibahan nila dalawa, di ba? Basically, ang articles of incorporation talks about, it is the charter that created the corporation. On the other hand, the bylaws, it is the rules and procedures for the internal governance ng corporation. Basically, yung difference lang dalawa. So, the former, the articles of incorporation, constitute the charter, fundamental law of the corporation, while the latter are merely rules and regulations adopted by the corporation. Si articles of incorporation executed before incorporation by the corporation, while the latter, usually after incorporation, mali tayo dito. Hindi siya executed kasi kasama siya sa kasama siya sa filing So, sabayan sila dalawa sa old na to. The filing for the former is condition precedent to corporate existence, while the filing of the latter, the bylaws distinguished, is a condition subsequent. So, yan lang si bylaws. Basically, kahalagan ni bylaws, it sets out the rules and procedures for the internal governance of the corporation. Yan lang yung tatandaan nyo sa bylaws. Another thing na tatandaan nyo sa bylaws is yung adoption niya. Di ba? Yung for the adoption, kailangan lang ng majority. Majority na board, majority ng stockholders or members. And in this revised corporation code, kailangan sabay na yung pag-file ng articles of incorporation sa isabay yung pag-file ng bylaws sa articles of incorporation, and para maging effective yung bylaws natin, kailangan ng certification galing sa SEC for that bylaw. Now, yung pag-create, yung pag-adapt, repeal, alter, amend ng bylaws, kailangan ng pwede nang i-delegate ng stockholders sa members or ng stockholders or members sa board of directors or trustees upon 2/3 vote. Pero yung revocation ng delegation na yun, majority lang. Bakit? To safeguard against abuse of power. So yun lang yung kailangan tatandaan nyo sa Title 5 bylaws. So, kasi maikli lang naman bylaws, 3 sections lang naman to. Pero importante yung bylaws sa pagpatakbo ng isang corporation. So with that, natapos natin yung first 5 titles ng corporation code natin. So, pagdating ng January 4, exam tayo, 3 hours. Mga 40 or 50 items. So, yun lang. Ano bang sabihin ko? May announcement ba ako? So, yun lang. Sige, bye-bye. Love you. Kain kayo mabuti. Hehe.